Hong Kong SI members, fellow practitioners, and friends, on behalf of the Hong Kong Securities Institute, I'd like to welcome you today to this special Hong Kong SI lecture series. My name is Angelina Kwan, and I'm a board member of the Hong Kong SI. I'm the chairman of the Professional Events Committee, and I'm your chairman and moderator for the next 3 events. So for those of you who are diehards in coming to these things, you're going to hear me for 3 days with our speaker. So I'm going to be here to amuse you just in case. I'm sure Adam will be amusing you, but I will be.
I can guarantee that I'm quite incapable of giving the same talk 3 days running.
You will be able to, no problem.
It won't come out the same way, though.
This is the first of a lecture series specially designed for licensed persons as well as registered officers. After the financial crisis in 2008, as well as the Lehman Brothers mini-bond debacle, we have seen a sharp increase in demand for training courses, especially relating to compliance with the sales process of investment products. So in view of the market needs, the Hong Kong Securities Institute has decided to launch this very special project that would include different kinds of training for members of the financial services industry. It would include the publishing of a guide, which I think you all are aware of, lectures for market participants, as well as a video recording of this presentation, which will be available on the Hong Kong SI website. So this is a quite different tact and approach that we've taken from the past. The lectures will be delivered both in Chinese and in English. For the Chinese side, it will be both in Cantonese and Putonghua, whilst the guide will be available in English and Chinese, both hard copy and electronic, so you can download it and it will be available for free. Whilst this project is only a one-off exercise, we hope that through multiple channels, the SI will be able to reach out to a larger audience and hopefully extend the residual effects of Adam's talk, as well as the guide, as well as working with various market players and stakeholders such as the SFC. So before we introduce the speaker, can everybody please take out their mobile phone? There's 155 people here. How many people are willing to place a bet that one phone will go off? Yeah. Oh, yeah, you've turned off your phone. I've turned off mine. So please, 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 can you switch off your mobile phone or your electronic devices? If we see you vibrating, we'll know that you've done the right thing. And to qualify for a CPT hour recognized by the SFC, you must stay here. You cannot leave. No, just kidding. You can go to the toilet. And you must stay for the Q&A session, which I hope lots of people will ask questions. For individual members, please make sure you screen your card. Finally, my committee is really struggling for talks, so please do, A, give us your feedback on these presentations, and B, give us some examples of things you want to hear from or people that you want to hear from. And chances are I can strong arm or do something to someone to get them to come and speak. So if you let me know, or our committee know, we'll get the speakers in for you. So without further ado, today we're very, very happy to have Mr. Adam Samuel to give us a presentation about the SFC Code of Conduct for Intermediaries and the sale of investment products, beyond the basics. Adam has a very, very diverse background. He's been a lawyer. He's a financial services compliance and dispute resolution specialist for over 25 years. He has a keen interest in facts about baseball. He combines knowledge of financial products, a regulator's rule books, as well as the law to provide an integrated look at advisors' responsibilities. Adam's qualifications combine those required for the Advanced Financial Advisor, the UK version of the Hong Kong SI Compliance Diploma, fellowship with the Chartered Institute of Arbitrators, and membership of the English and New York bars. He's a member of the UK Institute of Financial Planning Ethics Committee, as well as a Chartered Institute of Arbitrators Practices and Standards Committee. He's also, in his free time, a co-chairman of the Institute's Arbitration Subcommittee. And from 1991 to 1995, he was an insurance ombudsman assistant, resolving over 600 financial services complaints brought by consumers. So who more has such background in terms of telling us about the financial services industry and resolving complaints? As a result, he was appointed the second or Deputy Personal Investment Authority Ombudsman in 1995, where he issued 72% of the decisions produced by that office during the relevant time. Pretty good statistics. And then from 1996 to now, he has worked for himself, training, advising, writing on financial services compliance. He wrote the only significant book on the UK financial services complaint handling in 2005, which I'm sure we can learn a bit about. And he has specialist areas such as advisor standards, complaints, as well as financial promotions. He's been a guest lecturer for City University and is also a member of the Hong Kong panel of the Hong Kong International Arbitration Center, who has appointed him as an arbitrator. So without further ado, please let's give him a round of applause, a rousing round of applause. Mr. Adam Samuel. No joke, he has a lot of qualifications. So I cut some of them already.
Thank you very much. This is amazing. I don't know how amazing, whether you realize how astonishing this hall is today, and this week is. Apparently 1,800 people, or 1,600 people, have signed up for sessions on financial advice and compliance. I don't know of a single city in the world, apart from Hong Kong, where if you offered such a program, you would have such a take-up. And it is an absolute thrill to find myself talking in front of this huge crowd, which must represent one of two things. It either represents a lot of people who want to know about how to deliver financial advice in a compliant way, or alternatively, it represents a lot of bosses who want to send their staff along to such a session. And I'm not sure it matters much which, because the golden rule of compliance, or the first step of compliance, is if you're actually interested in discussing the subject, you're far less likely to break the rules than those people who say, with perhaps a great deal more knowledge, oh, it's easy, it's straightforward, we just do it like that, that's the way we've always done it. Because the way we've always done it is the way you usually end up in trouble. So the fact that all of you have taken the trouble to come along and engage with the subject, whether you agree with what I have to say or not, it almost doesn't matter, is a very, very positive sign for the future of compliance within Hong Kong, and indeed the future of financial advice, because I'm not sure there's a great deal of distinction between the two.
Or maybe they just thought you were very, very compelling and your reputation preceded yourself. So.
I doubt it, and even if they did, it's mind-boggling, but that's my name anyway, and we ought to start off with a fantastically long and complicated disclaimer, which, trust me, I didn't draft. I'd like you to know this. Now we've done that, let's get on with the presentation. Officially, our talk today, as with this week, is on the SFC Code for Intermediaries. However, I have already discovered that it actually doesn't matter whether we talk about it and to give our presentation today on the SFC Code, because many of the things that are in the code are part of good practice. And while the SFC Code does not have the force of law in Hong Kong, apart from the fact that the SFC can obviously take disciplinary action on the basis of it, it does constitute what is best practice in Hong Kong and indeed many other places in the world. The code, you know, probably, was recently amended, not vastly, in 2010, this year. There are other tools, though, that you should be aware of. The FAQs issued by the SFC, which are on their website, which is that address. The other thing that is probably a less well-studied resource, the SFC publishes, in fairly brief form, a whole series of examples, a number of which will turn up anonymously in the handbook. We've kept the names out. One name we couldn't keep out was Barbarasia, because there are 2 Court of Appeal decisions in that case, one of which concerned a customer of this firm who sued them for negligence, and one of which concerned an appeal against disciplinary measures taken by the SFC itself. And these represent surprisingly good sources of information about how the law would see a lot of the financial practice that may or may not have been going on at the time. In the same way that no man is an island and Hong Kong is only an island plus a bit of plus some mainland plus a lot of other islands, I would urge you not to think entirely in terms of Hong Kong. There is an enormous amount of discussion across the globe now of rules which are remarkably similar to the ones you have to deal with. We've already found ourselves discussing a discussion session this morning, the enforcement activities in the US, in England, a European directive which takes similar approaches to your code and similar approaches to your law. And as a result, they are also sources of information on this subject. But without further ado, you should become familiar with your code. It's far stronger and far more meaningful, I sometimes think, than people realize. It kicks off with 9 general principles. And for the purposes of today, numbers 4 and 5 are absolutely central. 5, the disclosure requirement, basically says you must disclose to your customers all relevant information that they need. And that's a very broad obligation. It's a very important obligation as well. And then after paragraph 1, which deals with the scope of application of the code, with which we don't need to delay ourselves, we then find 2 quite interesting paragraphs which deal with expanding the principles. Paragraph 2 expands the notions of honesty and fairness. Paragraph 3, what is meant by diligence. And we find ourselves running backwards and forwards from paragraph to paragraph here, from the general principles to paragraphs 2 and 3, and then to the more specific paragraphs that relate to conduct of business, which are 5 to 16 essentially, and paragraph 5 in particular deals with advice. So that's your route map. I want to start off, though, by saying something a little controversial, or fundamental, depending on which way you look at it. Everywhere I have gone this week, we have found ourselves discussing this, and rightly so. Okay, if that's true, that except for the super sophisticated professional investors who may just ring up and say, I want to buy the following securities, how are investments in Hong Kong sold? Nothing wrong with selling things. I want to make that clear. Well, I think they actually come from 2 places, and one increasingly rarely. The one that I think is becoming less and less fashionable, and probably with good reason, is promotions, advertising. I'm not saying that people don't use advertising, but to use advertising on its own to sell an investment product is increasingly difficult, and one of the many reasons for this is that in order to comply with General Principle 5 again, provide enough information, you have to put on your advert so much material that it becomes impossible to use the thing to sell. And you have other provisions of the code which require advertising effectively to be clear, fair, and not misleading, to use an English expression, which I think actually summarizes your rules quite well as well, and certainly the SFC's understanding of what they mean. So every time you have to say something positive about a product, you're effectively having to cancel it out with a negative. Which leaves us with advice, or solicitation, which is a term that you find in the code here, and which I'm not sure I entirely understand. Advice I do understand, however. Let me explain to you what the problem is. So, if you think you're selling investments, if you say to somebody, I'm not your advisor, but it would be a good idea if you bought that. The laugh is good, very, very encouraging, very pleasing to have that immediately. You see the problem straight away. Let's widen it slightly. You've got a choice, really. To meet your requirements, there are these 3 different investments. But it's up to you to decide which one you think you should have. Is that advice or not? It's advice. Any time you express a preference for a client for 3 things over the other, I don't know how many millions of other options, you are giving advice, whether you meant to or not. In the Barber Asia case, it was argued that by the firm it did not give advice. It said it gave the client some suggestions. But the judge was no more impressed with that argument than you appear to be, and quite rightly so. You're obviously all on the same page.